Vice Chair of the Zoning Board of Appeals, standing in for our Chair, Kevin Mack, tonight. I'd like to welcome everybody. The first order of business is calling us to order, and then the second is Pledge of Allegiance. If everybody will still please stand. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Were all the notices put out? Yes. Great. Can I hear a motion to adopt the agenda?
I move that we adopt the agenda.
Second.
All in favor? Did everybody have a chance to look at the minutes from the March 23rd meeting? Were there any corrections or additions? Do I hear a motion to approve?
I wasn't here, so.
I'll make a motion to approve the minutes from the last meeting, March the 23rd, 2023.
Second?
Second.
All in favor? So our first action items are 6 and 7, which are an appeal of the decision of the zoning and development administrator's decision. And the applicant has asked to combine those since they're the exact same issue. So we will combine items 6 and 7. Our rules of procedure allow the applicant 20 minutes to present. If you need a little bit more, since we're combining 6 and 7, we'll be happy to grant you a few more minutes, and then the county will present their case. So, Mr. Williams, are you presenting on behalf of the clients?
I am, Madam Chairman. Thank you very much. For the record, I'm Chester Williams. I'm an attorney from Hilton Head Island, and I told Mr. Nielsen I used to sit in that chair for 16 years before, so this is the first time I'm on the other side from y'all. So, but can I represent Mr. and Mrs. Rapogel and Mr. and Mrs. Van Rossum with respect to Hillary Austin's decision that she won't renew a previously existing approval for short-term rentals because it's a violation of the applicable covenants. And I understand that y'all had a whole slew of hearings with folks from Coffin Point about short-term rentals. And it's an interesting situation out there because there are at least a half dozen, maybe 8 or 10 different sets of covenants applicable to different sections of Coffin Point. Some are very explicit and say residential use only. Some say residential and agricultural use only. The covenants that are applicable to my clients' properties don't say that. And so I want to walk you all through this. So the issue, well, let me take a quick look here. Mr. and Mrs. Van Rossum purchased their house at 179 Sea Pines in September of 2012. And the following year, they started renting it out, June of 2013. January 2018, Beaufort County began requiring accommodations tax collections for short-term rentals, which they promptly did, and they have consistently paid their accommodations tax ever since. In December of 2021, they were told they would have to apply for a short-term rental permit, and they did. And in March of the following year, 22, they received that permit. In August of 2020, and this is not in the packet that y'all received, and it should have been because this is part of the county's records. In August of 2022, the Van Rossums received a violation notice saying that they were in violation of the short-term rental. But after they went through that, and I think Ms. Austin will confirm this, they decided no, that there was no violation, that the covenants that the people were complaining about weren't applicable to the Van Rossums or the Rapogels. And they went on about their short-term rental operations. In January of this year, they applied for a new annual permit, but this time it was denied in March of this year, in February of this year, excuse me, because Ms. Austin said it was a violation of the covenants. In 2022, it wasn't a violation of the covenants. Not once, but twice that was determined. Once when the permit was issued, the second time when the notice of violation was resolved. So let's take a look at the language that's applicable to that's part of the covenants that are applicable to the section of Coffin Point where my clients live. And this is the eastern point down that's on the beach. And what the covenants say is, all lots as above described shall be known and described as residential lots. And no structure shall be constructed, altered, placed, or permitted to remain on any residential building lot other than a single or double family dwelling, not to exceed 2.5 stories in height, and a private garage for not more than 2 cars. Paragraph 2 says, no noxious or offensive trade or activity shall be carried on upon any lot, nor shall anything be done therein which has become an annoyance or nuisance to the neighborhood. So the question is, does that language prohibit anything other than single-family residential use? Ms. Austin says, yes, it does. We say, no, it does not, and we're hoping to convince y'all that we're right. If you can get the PDF, that is the aerial zoning map 01. There's a series of 01 through 08.
Can you put it up so we can see it?
That's
Yeah.
And, Mr.
Oh, I see. 01.
01, yes.
Rob, can you get it on this
Okay,
screen
yeah,
up here?
it is. That's this one.
Mr. Williams.
That is,
That screen is on?
I don't think
No.
that's 01, but that's,
Oh, wait, hold on, I think it's, I'm sorry. Here it is.
and that
Can-
is a,
Excuse me, Rob, can you turn this screen on so we can see it?
Oh, okay, sorry about that.
It's hard for us to look at that way.
Yeah, it's smaller too.
And Mr. Williams, just a question while they're doing that, so I'm clear, are the covenants here that are the book 212 at 1689, these are applicable to both the properties?
yes.
Okay, all right, that's what.
Yeah, the property's right across the street from
Okay,
us. Yes.
that's what I wanted to.
And that's why I said the issues here are absolutely identical.
Okay, I just wanted to be.
So number one, this is just a screenshot of the county tax maps of the Coffin Point area. If you could go to number 2, please. Well, leave that one there for a minute, Rob. That is the first page of the subdivision plat of the area of Coffin Point that we're talking about. And again, it's the very southern point, eastern point, and our client's lots are on that subdivision plat there, all right? That again is a Coffin Point area with one of the particular areas that's subject to a particular set of restrictive covenants highlighted. Nothing having to do with our property. And again, I have all those restrictive covenants, so we can get them all out and read them so y'all can see what they say. But what they say, what the other ones say, the covenants that aren't applicable to my client's properties are really irrelevant, except to show that there are different sets of covenants at different areas of Coffin Point, and they say different things. Like I said before, some of them do explicitly prohibit anything other than residential use. These do not. If you can go to number 3, please. Yeah, the yellow area shown in that last one is subject to what's referred to as the MACMO covenants. And that was a company that was Elred Moody and one of the Mateers who developed that area and subdivided and sold it off subject to those particular covenants. You see the gray area there that covers a substantial part of the western part of Coffin Point. That's the area that the Coffin Point Property Owners Association says is subject to their covenants. And again, you notice the area down at the bottom on the east side, that's not included in there. My clients are not members of the Coffin Point Property Owners Association. They don't attend their meetings, they're not subject to their restrictions, and they're not subject to their assessments. You can go to the next one, please. So, This has got the same thing as the other two, the Macbo and the Coffin Point, but you see the red area down at the bottom. That's the area that's subject to the covenants that are applicable to my client's properties. Completely separated from the rest of the properties, isolated down there by itself. And that's the only set of restricted covenants. There's a supplement to it that my client's properties are subject to. In your packet, there's a legal opinion from Jim Grimsley, well-respected attorney here, saying, yeah, those are the only covenants that are subject to your property, and they do not prohibit other uses other than residential. Go to the next one, please. And the other ones I have are there just to show you the different areas. You see the little purple area out there? That's an area that is subject to a set of covenants that one of the peers put on the property. But he said specifically, not applicable to this tract here. And there was one other one that I had a difficult time identifying on the tax maps. But again, it shows you the jumble, the mishmash of restricted covenants that are in that area. Which one is that, Rob? Is it?
Number 5.
What's number 6 show? Number 6, that shows, you see the little green area there in the middle? That's an area that's subject to a different set of covenants. You know, in addition to the Coffin Point Property Owners Association covenants. And I think there are 2 others that are similar that follow, that show different tracts, maybe actually 3 others that follow, that show different tracts that are subject to different covenants. So, I mean, I'm counting probably 7 different sets of covenants. Next one. You'll see this is added a little pink area there on the left-hand side. Those lots there are again separate to subject to a different set of covenants than every place else out there in Coffin Point. And the next one, please. Then you see the light blue area that appears there. Again, different set of covenants applicable to it. Is that number 8?
Yeah.
That's all. So, what is it? So we see 1, 2, 3, 4, 5, 6, 7, at least 7 different sets of covenants there. But the question is, which one are applicable to our client's properties? And it's the ones that Mr. Browning pointed at, deed book 212 at page 1689. And the county's interpretation in 2022 was no problem for short-term rentals here. Here's your permit. In August, because of complaints based on a different set of covenants in the Coffin Point area, our clients got the violation notice. But that was rescinded after the issue with the restricted covenants was resolved. But then, and we don't know what changed here, then earlier this year, note the covenants prohibit anything other than residential use. So short-term rentals and commercial use, so you can't do it. But read section 2 of the covenants. No noxious or offensive trade or activity shall be carried on upon any lot. Trade. I don't see any way that any reasonable interpretation of the term trade could be limited to solely single-family residential use. Trade is business. Trade is commercial use. The covenants clearly provide for trade use. They do not explicitly prohibit residential use. It just says that the lot shall be known as residential lots and you have to build a single-family residential structure on it. Doesn't say what you can and cannot do with that structure. Other than in paragraph 2, it says, well, you can carry on a trade or other activity as long as it's not an annoyance or nuisance. And that, to us, is the rub right there. That is the line that says, no, it's not subject to just residential use. The covenants do allow uses other than residential use. And like I said before, the Van Rossums have been renting their house for almost 10 years now, since July of 2013. The Repogles started the following year. They followed all the rules. They've done everything they're supposed to do. They paid their accommodations taxes, their business licenses. But now something has changed and we don't know what that is. And because of that, we think the county's interpretation of those covenants is wrong, and that Hillary's decision regarding the issuance of the short-term rental permit should be reversed. Now, Mrs. Van Rossum are here, Mrs. Replogle are here. If y'all have any questions for them, if you have any questions or comments for me. So that's what the covenants say. What does the law say? Rob, the notice of violation is there if you want to put that up on the screen, because I still don't understand why y'all didn't get a copy of that. But it was issued and then it was rescinded, which is all the more evidence that, yeah, short-term rental is allowed on this particular piece of property. Mr. Bromley, you pointed out at one of the other meetings that I watched one of the recordings of, that covenants being in derogation of the common law are strictly construed so as to allow the broadest and freest use of one's property. That is specifically the point of the Penny Creek Associates versus Fenwick Tarragon Apartments case decided by the Court of Appeals in 2007. One of the head notes, Mr. Bromley's from me, that restrictions on the use of property such as restrictive covenants are historically disfavored. Thus, to enforce a restrictive covenant, a party must show that the restriction applies to the property either by the covenant's express language or by plain, unmistakable implication. Restrictions on the use of property will be strictly construed with all doubts resolved in favor of the free use of the property, although the rule of strict construction should not be used to defeat the plain and obvious purpose of the restrictive covenants. The plain and obvious purpose. If the writer of those covenants had wanted to limit the property strictly to single-family residential use, you could have very easily said so. But they don't. They specifically allowed for trade and other activities. So when you're looking at these covenants, if there's any doubt whatsoever, the law requires that you resolve that in favor of the broadest and freest use of one's property. Likewise, Purdy versus Moise, the same principle applies to zoning ordinances. This is a 1953 case from the South Carolina Supreme Court that is still the governing law in this state. Statutes or ordinances in derogation of the natural rights of persons over their property are to be strictly construed and should not be impliedly extended to cases not clearly within their scope and purpose. Zoning ordinances are strictly construed against the government and in favor of the property owner to allow for the broadest and freest use of one's property under the applicable restrictions. Same thing in the Supreme Court from City of Myrtle Beach versus Jewel P. And I'll be glad to submit copies of these cases for the record, because I think the rules do require that. Ordinances in derogation of natural rights of persons over their property to be strictly construed as they are in derogation of the common law right to use private property as to realize its highest utility and should not be impliedly extended to cases not clearly within their scope and purpose. We think that a plain reading of the applicable covenants here, and Jim Grimsley's letter confirms that these are the only covenants that are applicable to my client's properties. A simple reading of it clearly allows for trade use, commercial use. It's a business activity. Nowhere in there is there an explicit statement that anything other than residential use is prohibited. That is applicable in some of the other areas of Coffin Point, but not here. The law, you got to strictly construe those covenants to allow for the broadest and freest use of property. Again, there is no way that anybody reasonably can look at the word trade and say, Well, that limits everything to single-family residential use. And the zoning ordinance itself must be strictly construed to allow the broadest and freest use of one's property. That's all I've got. If you have any questions,
Does anybody have any questions now?
I would like to include in the record a copy of the notice of violation, so that's there. And the rules require that if I'm citing cases, I provide copies of those for the record, which I will do here also.
Thank you.
And even though both cases are combined, I don't think I took my full 20 minutes back.
Not quite. Thank you.
And one other thing I'd like to get to the record is a letter dated yesterday signed by a whole slew of our clients' neighbors in that neighborhood, saying that they don't have any objection to short-term rental use in the area. So I'll give these to Ms. Austin to include in the record.
Thank you. Would the county like to?
Thank you, Madam Chairman, or Vice Chairman.
Hi, I'm Brian Holbert. I'm your new deputy county attorney, and I'll be representing the county and Ms. Austin in this appeal. I think it's important to take a step back and to look at where we are. In 2020, September of 2020, we passed the ordinance where we regulate short-term rentals. That's when it came into being. So after September of 2020, the planning department began the process of setting in a process to regulate the short-term rentals. And in doing so, they followed the ordinance, the new ordinance, section 4-1-360, in which they set up to where you're required to seek an annual permitting permit from the zoning department and a business license for short-term rentals. The county council placed short-term rentals in the office part of the land use, part of the community development code. In section 3-1-60, under offices and services and land use category, the county council placed lodging, short-term home rental. And the purpose of doing that was to say that when you rent your house out for 29 days or less, that's lodging and that's commercial activity. So the county council made that legislative determination that the renting of your house for 29 days or less is permitted where it's zoned and permitted as special use, but it's a commercial activity, and that's where we're at. So in section 4-1-360, they set up the standards establishing the operating of short-term rental properties. They all have to get that zoning permit, I said, and a business license. In addition, there were submittal requirements listed in paragraph D2 of that section, and of particular importance was the restrictive covenants affidavit signed by the applicant owner in compliance with state law. So anybody applying for short-term rental zoning permit had to address whether or not there were restrictive covenants in their neighborhood where they're wanting to rent their home at. As Mr. Williams said, both of his clients submitted their application once the law came into effect to seek a zoning permit and a business license. Our process was brand new at that time. They submitted an application and they checked the block in there answering the question about whether or not restrictive covenants affected the house and the rental of the house in that neighborhood. And they checked no. Each of the applicants checked no, that restrictive covenants either didn't exist or they didn't affect the short-term rental activity. When Ms. Austin was reviewing the zoning applications, she in part relied upon that representation from the applicants that there were not restrictive covenants that affected or prohibited short-term rentals. That's in part why they were granted that initial zoning permit last year, the first zoning permit under the new regulation that we had. In anticipation of the flood of applications coming in to the county because of the new regulation that's in effect, planning department got together and came up with a plan that, all right, so we didn't inundate this body with numerous applications for special uses for short-term rentals. They would look at the applications, and if they paid their hospitality taxes, or accommodations taxes, and their other taxes, they were current in that, then they would approve the application unless there were restrictive covenants that prohibited it. So, these applicants provided the proof that they paid their taxes, they were current on their taxes. So Ms. Hillary Austin looked at the application, saw that they didn't have restrictive covenants that were affecting it based on their conceptual plan application, and they had to prove the taxes, so she issued the permit from the zoning department rather than having to come before this board for a special use exception for the neighborhood. That's why they got that first initial permit for short-term rentals. In the summer, when they had that application, our code enforcement office started getting complaints from the neighbors as far as short-term rentals occurring there and saying, hey, here's restrictive covenants, and they prohibit the rental of short-term rentals in our neighborhood. They responded to that. Now, the complaint that Mr. Williams referred to as far as, hey, they got this notice of violation, and they called the code enforcement office and talked with them, and Ms. Austin regarding that complaint is correct. But they were confused as far as there being numerous sets of covenants, up to 7 sets of covenants in that neighborhood, as Mr. Williams represented. So they were looking at different covenants, and based upon that, determined, yeah, okay, these covenants don't apply to you, so there's not an issue, continuous business. As she had time, she looked further into the issue, and last fall, and that's when the determination was made, all right, there are restrictive covenants. These are the covenants that apply to these 2 parcels based upon what the deed says and the covenants say, and the covenants have the language that prohibit short-term rentals in the neighborhood because the covenants require residential use on each of the lots. There's 4.
Which, Mr. Holbert, where is that short-term rentals prohibited in the covenants?
It's paragraph 1. She's relying upon paragraph 1. She interpreted paragraph 1.
Is that your position?
Yes.
I've got a question. All short-term rentals require a special use?
No,
permit?
there's different, if you look at the code in section 3.1.6, the consolidated use table, in that paragraph.
But are you aware of cases like Wells versus Sea Ponds, which denote that a short-term rental still to retain, the home retains a residential quality?
That's a completely separate issue with Sea Pines, because as you know, Hilton Head, that's.
Well, but
most
that's
of their-
the South Carolina case law.
It is, but most of their economy is set up for residential.
So,
The case addresses covenants that allow the rental of the property. Their covenants allow it, and they say that, all right, if you have a guest suite in your house, when you rent your guest suite, you have to rent your entire house as well. That's what that case deals with, as far as that. So it didn't term that residential changed the nature of it. That was interpreting the law as far as, all right, the issue was, do you have to rent your entire house or not?
would you take the position that these prohibit the leasing over 30 days of your
No,
house?
The county.
Well, but leasing's not mentioned
The
in these.
county does not prohibit the short-term rentals of the houses of that character or that neighborhood, okay? We zoned it T2R, in which short-term rentals is permitted 29 days or less, okay? Unless there's restrictive covenants. So, the county has zoned it T2R.
But what if the short-term covenant, or what if the covenants allow for short-term rentals?
Then they can rent. Then they can have short-term rentals. It's a covenants law. That's the whole issue that's here before the zoning board. Do the covenants prohibit short-term rentals?
Well,
And the issue is, here's where you have to distinguish that. For short-term rentals, the county has zoned it T2R, and short-term rentals is allowed for those.
Well, it's a special use.
Well, you have to come before you get the use.
Well, I just want to make something clear here, because it's your position, correct, that these covenants that we're talking about, 212, 1689, don't prohibit leasing over 30 days.
That's correct.
Okay, well then, is there a specific prohibition on short-term rentals that's found in the covenants?
Stay with me here. The leasing for 29 days or less has been determined to be commercial activity by your county council. They passed that ordinance.
Do these covenants prohibit commercial activity?
The covenants, they do. They say it has to be residential use. That's what
How do you
paragraph one
interpret
says.
trade?
What's that?
How do you interpret trade?
Your, stick with paragraph 1 first, all right?
Well, but I'm
It
looking
says
at
the
paragraph
lot-
2.
Let's let him finish and then you can ask.
I mean, we can debate that all day if you want, but.
I mean, I just think the law is fairly clear about this.
Well, the county council has determined that short-term rentals is a commercial activity. So the whole purpose of Hillary's determination was that, all right, it was allowed, that's why she got that initial permit. Then the complaints came in, she saw the covenants, and she looked at it and says, yes, it says it has to be residential use. That's what it requires in paragraph 1. The action taken by Ms. Austin was that she then decided, rather than revoke the permit at that time, she would let it come to expiration, and then on renewal, she would inform them and give them a period of 6 months to close up their business. So she was being generous in giving them the 6 months to the conclusion of the initial permit, and then she renewed it for 6 months and gave them 6 months to wrap up their business. So they got 9 to 12 months to wrap up their business, what they got. They chose to appeal and they're here. The reason that the commercial activity, or that the permit is denied, that she won't renew the permit after this, is because of section 629.1145 of the South Carolina Code of Laws. That prohibits the planning department from issuing a permit if the covenants prohibit that activity. So the question is, do the covenants prohibit that activity? That's why it's denied. It's not that the county said no. The state of South Carolina says no permit if the covenants prohibit that.
So that would just be because what you're saying is that leasing's not prohibited. That doesn't change the character to commercial.
If they lease their
But
property
because
for
the-
30 days or more, that's not commercial activity under the county code. That's just leasing your home. So based on the short-term rentals, it wouldn't qualify. That wouldn't be the issue.
I've got a question on that. If your home was in an area that didn't have any covenants and it was only, you couldn't have any commercial activity, but you could get a special use for a short-term rental with that, you wouldn't be, you could have
Well, you're
that
mixing two things
business.
there. If it prohibits commercial activity, short-term rentals is commercial activity. So if it prohibits commercial activity, you can't do it. But if it
Yeah.
allows commercial activity,
That's
You
what is
could
the
do it.
problem with the ordinance.
so it comes down to your interpretation of the definition of the covenants. In looking at the covenants, read the first paragraph. For further explanation about the intent of the drafter of the covenant, look at the supplemental part of the covenants from the ones drafted a few years later, when they tried to put a swimming pool on the property there. In that part of the covenants, they refer back to the pools are allowed, but only, no public pools, only for the private use of the private residential purposes is what it refers to. Can you pull that up?
But, I guess my issue is that the covenants don't even mention leasing, but you're saying that, hey, leasing would be okay. And here, if there's not and if the covenants say leasing's okay, the case law would
Well, the covenants are silent.
would allow for you to do short-term leasing unless there was a specific prohibition in it in the covenants. I mean, and so, because that would allow for the freest and most use of the property. And so where I'm wondering is that, you're saying, hey, one's okay. It's not even prohibited or mentioned in the covenants, but this other one's not okay when trade seems to be clearly allowed.
I think that.
Well, I don't think it says that trade is allowed. All it says is, no noxious or offensive trade or activity shall be carried on upon any lot, nor shall anything be done thereon which may be annoyance or nuisance to the neighborhood. That's just prohibiting a nuisance, of that is. That's your standard nuisance language is all that is. That's just saying, no nuisance on the property as well. That doesn't say commercial activity is allowed or trade is allowed.
But-
They're that's just their interpretation to try to get it to where you fall into saying, hey, you can have that short-term rental, even if it is commercial, activity, because it says no obnoxious or offensive trade. Because you're prohibiting this, it must allow this, is what they're arguing, and that's a followable argument. Focus on the first part of the first sentence. All lots as described shall be known and described as residential lots, all right? So the intent is residential lots. When you look at the supplement to restrictive covenants, you'll see there, it tells you that placed on the said lot in conjunction with the private residential use of the said lot or lots. I mean, they're referring back saying residential lots 10 years later. That's clearly their intent as far as keeping it residential and not commercial. It doesn't allow for commercial activity. And their whole intent when they drafted that was to keep it a residential neighborhood, not a commercial area. And look at the entire neighborhood. It's a residential neighborhood. You don't see any businesses in there.
I just have a silly question. Does that mean that I cannot rent for 29 days, but I can for 30?
Yes.
Whoa. I guess it wasn't such a silly question.
The reason is that county council determined that short-term rentals would be 29 days
Yeah, I
or less.
understand that,
So 30 days is not a short-term rental.
I understand that.
And
And
you
only
can,
short-term rentals is determined commercial activity there. Under that,
Oh, so 30 days is not commercial activity, but 29 days is. Is that by definition?
if it's your one house. Now,
Per-
we have-
per
Well, I'm
the
saying one
ordinance.
house, no, we're talking about one house.
Right.
Talking about her house.
Yeah. It would not fall
Okay.
under that definition, we wouldn't have that issue. Any other
That's a little
questions?
weird to me.
You have to determine at some point what's short-term and what's not.
Oh, I know, but.
yeah, but you can run into a situation where, there are covenants that allow for, short-term rental but at the beginning of the covenants, it's gonna say, hey, these are single-family, residential dwellings, and then it'll go on later to the leasing section, and it'll have an allowance of leasing, and if it doesn't prohibit short-term rentals, then it allows for it.
You're absolutely right.
But the way that Beaufort County's been taking this position is that, hey, if there's the wording, single-family residential, it's, the short-term rentals prohibited. Where that's not necessarily what the covenants might technically allow for, or what case law, how the courts would decide.
Well, there's no case law on the interpretation of that, is what the problem is. So we're not there yet where we have case law that we can rely upon as far as that interpretation. The case that he cites has no part in here because that dealt with an issue on Hilton Head, as I said again, where it dealt with, all right, if you have a home and you have a guest suite, if you rent that guest suite, you have to rent that entire house to go with it. You can't rent one or the other, is what that dealt with.
Any other questions for the county? Mr. Williams, our procedure says that you get the final word.
Thank you, Mr. President.
I have a question before you
Oh, yes,
start.
ma'am.
Do either one of these houses have a swimming pool in it?
So, for the most part, we agree with almost everything that Mr. Hulbert said. The procedure leading up to it. The bone of contention is paragraphs 1 and 2 of these covenants. He says paragraph 1 limits it to residential use. But read paragraph 1. The word use doesn't show up there anywhere. It's not in there. Paragraph 1 describes the physical characteristics of what can go on the lot. You have to build a residence there. It doesn't say anything about use at all. Paragraph 2 does address use, trade or activity. Like I said before, I don't think there's any reasonable way to interpret the term trade to be only single-family residential use. And I think that's the crux of the issue here. Mr. Holbert's right. If the covenants, if the application for a short-term rental violates the applicable covenants, the county's prohibited from issuing the permit. Our position is that the covenants allow for uses other than single-family residential use. There's no prohibition words anywhere in there. There's nothing that says residential use. And that, we think, is the bottom line.
I have a question.
Yes, ma'am.
These were written in 1973, before anybody even heard of short-term rentals.
Correct.
So how do you interpret in the addendum, when they're talking about the swimming pools, when it says, constructed or placed on the said lot in conjunction with the private residential use of the said lot or lots? So,
That
I
might
mean,
take
it's-
it into a different realm, but
but, I mean, it's the same person that wrote the first one, and that they're saying residential use of the lots at that point.
correct. But still, paragraph 2 is still there, trade or activity. You can do a trade or activity that is so long as it is not an annoyance or nuisance. Can you have a home business in there? That's a commercial, that's a trade. Can you have a consulting firm office that's in there? Can you have your engineering consulting firm in there where people come to see you on occasion? That's not a residential use, but that is a trade or activity, and as long as it's not an annoyance or nuisance to the neighborhood, paragraph 2 specifically allows for it.
But our zoning code allows for those if you live on the property.
Okay? But still, the bigger issue is a trade or activity. And the short-term rental use of the property is clearly a trade. And it's permitted under the covenants, and it's permitted under the zoning, and my clients are entitled to their permits.
Any other questions for Mr. Williams? Okay, for voting on this motion, we have 4 options according to our procedures. We'd have no public comment on an appeal. But we're going to have discussion, but I was going to give you what our options are. So we can affirm the action or the decision of the director. It's our first. We can modify the action or the decision of the director. And in that end, the board shall have all the power of the director and may issue a permit or direct that a permit be issued. Or we can reverse the action or decision of the director. And to that end, the board shall have all the powers of the director and may issue a permit or direct that a permit be issued. So we can modify the action, we can accept the decision, we can reverse the decision, or we can remand the action or decision of the director for such further proceeding as the board deems appropriate.
You know, to me, this issue, I think, is fairly clear. And I think, I know what I'd be telling these folks if I were issuing an opinion, but my vote would be to reverse the board and issue the permits, because I don't think the covenants prohibit short-term rentals, and I don't think that, and I think that they answered appropriately on the application.
I agree.
I would think that, since this is in Coffin Point and we've had so much heartburn about short-term rentals in Coffin Point, that we should amend it to have them come through the short-term process before the board, so that we have the neighbors have the opportunity to express their views.
Well, there's nobody here now. Well, then why was there no public comment?
Because there's
Oh,
no.
never mind, you're right.
It's an appeal.
Administrative appeal, I'm sorry, you're right. You're right, administrative appeal's different.
Yeah, there's no public comment.
Haven't they already provided everything else that would already go through that?
No, because they were existing, so they didn't go through the process like all the ones that we see now. Yeah,
They submitted all of it.
right, but they didn't come before this board.
So what?
But if we were saying, if we took the position that the covenants, well, I guess. we still
Satisfied the
have to
special
issue-
use permit, then they would just have to make sure that they got their, went through the zoning office to get the rest of their,
Yes. because
make
I
sure
have
that
to
they had their
notify
business
everyone
license and
within
all of that.
500 feet.
I would
I have several questions. With each of these 7 different districts, and we obviously have turned down a lot of them.
Mhm.
And I'm curious as to the differences, and then with your noxious part of it, what the complaints are. Are they because there's things going on that are considered to be objectionable to people that have to drive by?
Could we
I
hear
mean-
from the codes enforcement?
Sure.
That's who was notified, right? The codes enforcement official?
Ms. Goucher's in the,
She's here.
Hello, I'm Officer Goucher with Beaufort County Code Enforcement. Just like you guys have all said, we initially started having these special use permits come in front of the Zoning Board of Appeals, and when it came to Coffin Point, after a lot of the neighbors got up and spoke about the different sections of Coffin Point, I went out and spoke to them, and I said, if you guys have any issues, I'm the person that you guys would contact, and I will start investigating all the complaints and all of these short-term rentals that are, on the property. I think the most important thing, we keep on talking about the covenants and restrictions. If you read number 2, I don't think, people haven't went on with the sentence. And it says that, thereunto which may become an annoyance or a nuisance in the neighborhood. And obviously, we see that there's several people in the neighborhood that feel that it's become an annoyance or a nuisance. And there's one particular individual here in the room that actually is within this covenant and restriction and has called our office several times to discuss this. And I think that there's some other people. I don't know where all the rest of the people that are in this room, where they reside in relationship to the different covenants and restrictions in Coffin Point, but I do know one individual that is within this area that falls within these covenants and restrictions, one of which lives on the particular road of one of the people on the agenda tonight, so.
Thank you. Any questions for Ms. Goucher?
Say something.
Nora?
Okay. We've been down this road. And like Brian said, county council placed short-term rentals under commercial uses. Now, Mr. Williams is saying, trade. There's also something in the ordinance under residential uses that states you can have a home office and you can have a home business. So if someone came in and wanted a home office, small office in their home, we would give them a permit because that's listed under residential uses. So, we have to keep, I have to look at the code and see where these things fall. When they came in, a lot of people were coming in. So we decided, if they were paying the accommodation taxes, we would just give them the permit because, they didn't have a business license. They were violating the county's ordinance. But if they have been paying, we would go ahead and give them a permit. And I did, and you know what, I wish I hadn't. I wish we hadn't come up with that to help. So here we are, and then the ordinance had just come out, we were looking at it, wasn't even sure where this thing fell, and then it hit, it's the commercial use, it's lodging. Mr. Williams, you're saying that It doesn't say residential use only, so I could build a hotel next door? What, no, that's what he's saying.
But there's short-term rentals that you cannot build a hotel there that are permitted in the
Short-term
county.
rental is listed with lodging.
So a short-term rental has to be in an area that you could build,
You can build a hotel in rural, and it's a special use. If you look at the use table, right where short-term rental is listed, lodging, less than 24 rooms, are listed in the same category.
Okay.
So if you are saying that these covenants doesn't say it's residential only, then what are we saying?
Sure.
Chester Williams again. No, you can't build a hotel on the lot, because that is not, it's a residential lot. And you can only build a single, double-family home. And that's, but the covenants do say that, okay? Here, let me. All lots as above described shall be known and described as residential lots, comma. And no structure shall be erected, altered, placed, or permitted to remain in any residential building lot other than a single or double-family dwelling. You can't put a hotel there. That's a silly argument.
I can put a bed and breakfast.
You can't put you can put a residential building that is a single or double-family dwelling. And you can carry on any trade or activity as long as it's not noxious and as long as it doesn't become an annoyance or nuisance to the neighborhood. And short-term rentals falls right under that category. The question, Brian's point was, state law and also the CDC prohibit the issuance of a permit for an activity if it violates applicable restrictive covenants. So the question is simple. Does short-term rental violate these covenants? Our position is clearly no. I'm sorry.
I think that with the annoyance or nuisance to the neighborhood, that would be important to hear from the neighbors if we go through the process.
That is an improper procedure in this hearing.
I know, not for this hearing, but if we can amend the decision
Well,
and
I
have
guess
them go through the process.
assuming that it's gonna be obnoxious or offensive, I mean, if it became that and they started violating the covenants, they would have to take up with their neighborhood association and they would have to go work it out, wouldn't they? If it violated that by being obnoxious or offensive. And if it stayed not obnoxious or offensive, then they would be, able to operate. It's kind of how
Okay, I think we've talked about it enough. Does anybody have a motion to make?
So, are y'all talking about sending it back with to allow it to come back through the process?
That was my suggestion.
With the directive that the covenants don't prohibit short-term leasing in this specific instance, but it would ultimately allow for the neighbors to determine or have some say as to whether they thought this was
I would think that's an option. I mean, the other option.
Which it certainly is an option, but it puts our client in a completely different position than everybody else who's similarly situated. And that just rubs me as being unfair.
Actually, it's not, because everybody else, I mean, if you applied for a special use permit for a short-term rental this week, you would come before this board.
If
So
you're new, if you've been paying your accommodations taxes, and you're just renewing your permit, am I correct? No, you wouldn't.
That was just a procedure because we had so much going on.
And,
'Cause it was in-
Everybody comes through the special use.
so even ones who were paying their accommodations
Yes.
tax before? Okay, all
Everybody
right,
comes through.
all right. We're okay with that.
I think that seems fair. You put forth a list of people who look for it, so.
everybody else.
So but by doing that, are we saying that we believe that it is allowed within the covenants? Okay.
Yes.
I can go.
would probably personally just go ahead and issue it. But, you know, if it were the, you know, feeling of the whole board that they'd rather have them come through the process, then not be fine with me. Well,
I think it's important for this particular neighborhood because we've heard, I mean, this room has been filled before, so it's,
I just want to make everyone, with the understanding that we are saying that it does not violate the
Yeah.
covenants by doing this.
mhm.
yeah.
Yeah.
Did anyone have any questions when this first, way back?
Just last year, you guys disapproved.
Wait, if we come up here so it's all on the record, please.
I meant when they first put in for the short term.
And just
Did
last
anybody
year,
It
have-
didn't come through this.
just
It
last
didn't
year,
come
in this
through.
very neighborhood, just up the street, the Mannings applied for special use, and you guys denied that special use.
It was different.
No, this is the same. Yes, it is, the same one.
They're 30 here.
Mr. Manning has different covenants, not him, there's somebody else.
So anyway, I just put that in front of the board.
I just wanted to.
Yeah,
I
please,
just wanted to.
order.
Yeah. All right, then I'd move to, say that the applicants would file, for a special use permit, but, and go through that process, but that, it would be under the, with the directive that in this case, these covenants do not prohibit short-term rentals.
I second it.
Can you say that again? I didn't hear it.
That, move that these, applicants.
That you're overturning the director's decision.
The covenants prohibit short-term rental and that they would go through the application, the special use procedure.
So basically, like they're starting fresh from
Yeah.
the beginning,
Yeah.
like anybody else would.
Yes, like anybody else would, but the covenants wouldn't be an issue. Yes.
And Lynn, you seconded that,
I
right?
second it, yeah.
So all in favor? Passes.
Thank you, Ms. Britton.
Okay, so our next item is Mr. and Mrs. King, also a special use permit. Since this is the, you might want to see how a regular special use permit goes. We see a lot of them, but this one does have public comments, which is limited to 3 minutes. So if you have, if you want to have any comments, make sure that you sign up and give the sheet to the county. So, Mr. and Mrs. King, if you want to come forward and tell us about your project.
First of all, I'm trying to keep my head from spinning right now from all that. We're absolutely brand new to doing something like this, so we're learning the process. Ms. Austin helped us be able to go through initial steps, and I know we have a few more.
And do you have covenants on your property?
We dug and dug and dug and dug and dug. I don't see any. They helped me a lot going through the system, and I'll be perfectly honest with you, there were like 2 or 3, and then 2 weeks later, I went back and they were gone. And I think they were so old that they expired, as best as I know. Because Miss Austin and I looked at it again, and we did not see anything of a covenant, because we are not sitting in an HOA, we're sitting on a road, off of the Brickyard Flint Road South.
Okay. Does anybody have any questions for the applicants? Would the county like to comment?
We recommended approval, because like you said, I didn't find any covenants and restrictions, so, they met all the requirements for special use.
Great. Do I hear a motion or any questions for the county?
I move we accept the, give them a permit.
Okay.
I'll second it.
All in favor? Passes. No,
I have
thank
a
you.
I have a question if you have a moment.
Sure.
So, in this short term, or in this zoning permit, like I said, we're learning. So we've got a zoning permit, we can do a short term rental. Now, after what just took place here, is that
Maybe you should.
if we're unfortunate enough to have, if we're unfortunate enough to
Don't
have
ask.
somebody
Yeah.
stay in the house.
You got the permits.
And cause disruption to the neighbors. I feel like that's something that we would work out with the neighbors unless that neighbor came this way and made a complaint in this office.
Right, yeah,
Correct?
that's correct.
Okay.
And the neighborhood they're talking about is, there's been a lot of complaints from there, that neighborhood.
Well, I just wanna make sure for our sake.
Right, yeah, no.
Because-
They're gonna call the police first.
Yeah, sure they are.
Yeah.
Sure they are. But in the meantime, you know, we have a whole family that lives across the street from us.
Mm-hmm.
You know, grandmother, daughter, aunts and all that. So, but in the meantime, you know, we know between police and neighbors, we would find out about it.
Yeah.
We'd have to work it out.
Yeah, probably if you talk to your neighbors and get them to call you if there's any
Oh,
issues,
yeah,
that'd be good.
absolutely, absolutely. And my wife has been great about being on these rental sites and she's learned a lot. of
Okay,
things.
good.
So we're good. So thank you for your
Thank
time.
you. Okay, now we have item number 10. This is Mr. Smoot, who is on Frith Island on a little teeny tiny lot out there.
Good evening.
Hello.
Hi. I'm applying for an application for a river buffer waiver. Do you guys all have the sheet that I sent in?
Yeah, we do.
Okay, good. I'm just gonna kind of roll through it if that's okay. Do you have, well, the parcel, just to kind of give you a quick overview of what the parcel size is. The parcel is only about 4,800 square feet, and maximum width off of the river buffer is about 50 feet, 45 feet, something like that. And so we don't have a lot of room to build outside of the river buffer, but there is a part that was cleared back in the 70s and has been, I guess, maintained since then, and we're kind of centering it over that clearing to optimize vegetation loss.
So was there a house here before?
Never was a house there before.
Okay.
But it's an empty parcel. It's the last parcel on this little, for those of you who've been out to Fripp, there's like
Yeah.
these little like tree houses that run out Fiddler's
Yeah.
Ridge. And they've got a single 10 by 10, like pillar in the middle. So as far as like, actual, like what the dirt we're digging and all that, it's gonna be just 100 square feet of real kind of, disturbance. So, kind of rolling through this, the setback wherever, I'm just gonna go to number 1. It says the OCR critical line setback significantly limits house size. And so, in a nutshell there, what it says is, you have to be under the average of the 10 adjacent lots. And we're almost half of the 10 adjacent lots. We're building a house that's 820 square feet. So any question, or 840 square feet, sorry. We bumped out a closet, but it has the same roof line. For the next one, number 2, is just the reduction of front yard setback to avoid the waiver. The front yard setback is weird on this one. It's actually really a side yard setback, but the way it works, so our side yards are actually what we need to move, and so we can move it 30% according to this. The side yard setback currently is 10 feet, so we can move it 3 feet. If we move it that 3 feet, we will have to take out maybe a little bit of vegetation, or at least do some trimming, but we might be able to do that. Number 3 is, and this is the one that I feel like is probably the most applicable, is the reduction of the OCRM critical line setback. In order to be reduced below the 35-foot setback, there's a series of things that says, except in areas where homes already exist, are located closer than 35 feet to the OCRM critical line setback. I did not have a chance to print out the pictures, but they are on top of the critical line. I actually have some neighbors here with me, fortunately, that could vouch for that. They're basically on the critical line. Most of these houses either have a deck or a roof line that's within 5 to 10 feet of the critical line. Let's see, and then says, in no case shall a setback of less than 20 feet be granted through administrative waiver unless the setback is to preserve a specimen tree We don't have a specimen tree, but we're really trying really hard to preserve a 24-inch pine that's right there by the deck. And there's another couple of larger things that aren't on here. There's some saw palms, and I don't know if it's a saw palm or just a smaller palm that's like 18 inches that wasn't marked on here. That kind of where the driveway area, parking area, it's not really a driveway, wraps around. That's where there's a palm that's pretty big. It's about shoulder width. And then if you keep going, unless to preserve a specimen tree historic resource, we don't have any of those, or to prevent the lot from becoming unbuildable. And I think that's really the crux here is if we don't get a setback waiver, this lot is basically unbuildable. There's really nowhere you can move this within these constraints that we can be outside of the 20-foot buffer. And yeah, there's just really not. It's 30 feet and the house is 30 feet. I got an 800 square foot house. It's itty bitty already. So, and then the last one's the stormwater stuff. And it's very minimal. We've got each one of these roof panels contributes about 100 square feet. We get about 60 gallons of runoff. I think, I'm actually a stormwater engineer. I think the best option here is actually to do like a trench around where things fall off and not gutter it.
Mm-hmm.
I would prefer things to go into like a rock trench, and just let it fall straight off, because that way you won't harm anything, you won't concentrate flows. I'm more of a dissipate first kind of guy. I don't like to collect it and then discharge it, because it's a lot harder to deal with, even off a small roof, so.
It appears though that if you moved the whole house to the west and reconfigured that deck, that you could get out of the way of that pine and get further away from the critical line.
So if we move things, I've got a couple of other options, if permission to approach?
Sure.
Okay. I've got some other options here, if people, like, this is one, you guys are welcome to pass them around. The problem with all these are that as you kind of start twisting things, you start hitting some of the vegetation that's there that's not really marked there. And I think it was page 3, it has kind of a little cloud of green. And the way it's positioned right now, it's in the middle of that clearing. So we're taking out one small saw palm for parking. That's it. Which I think is awesome. I don't know how we managed to do that, but and then there's another alternate.
But I mean, if the deck wasn't wing-shaped, if it was rectilinear, and if you pushed it this way, I think you could make it work.
Oh, you're saying, okay, changing the deck?
Yeah, so it's not a trapezoid, it's a rectangle.
Unfortunately, this is a pre-built and we've already ordered it. I could see what I could do.
Well, it seems like the deck would be,
I'll pay for it twice, but yeah. The real thing here, though, to me, is the distance from the critical line of where our actual disturbance is. This is not what's going to be disturbing anything.
Right.
That little tiny hole
but
in
that's
the middle-
not, but that's not providing a buffer from the critical line. And I mean, it's not providing, that's what the critical line is to provide
Right,
a
but we're not
buffer.
removing any vegetation. Here, you want me to back up again, or?
No, you're fine.
Okay.
Well, you probably need to be at the
Okay, yeah.
microphone.
We're not providing, we're not, anywhere but that little tiny column, we're not really affecting vegetation, so the buffer itself is being maintained. If you start to move some of that stuff around, like, you can still have shade in a buffer. That happens all the time, overhanging and all that, so we can, and I would gladly, if you want me to reestablish buffer underneath the house, I would gladly plant underneath the house. Actually, we plan to plant underneath the house and stuff. Wherever we don't have anything, we're gonna put in a few more saw palms and things of that nature to kind of, we wanna stay, the close, also another thing is the further we move, so that big pine by the deck is approximately 50 feet tall. We will be disturbing part of its root zone, because the way trees' root zones work is if you take a tree's height and you can basically make its height its radius, and that's what would be affected. The closer you get to that root zone, the more of it you affect, because you kind of have like a shadow effect, right? So as we move it closer to that root zone, we're risking the health of that tree, which is another thing that we tried to optimize.
Especially in that area, even if you stretch the house out,
So
and made it longer, you'd be putting all of that foundation all the way across that, you know,
I'm not saying change the shape, just change the shape of the deck and then push the whole house to the west, I guess southwest a little bit. Any other questions for the applicant? County?
It's only 4 feet from the critical line, so I said redesign the house. What he read was what the staff would look at. To
Right.
be able to grant a waiver, so that doesn't apply to you guys. So, it's just, yeah, the lot is small, but I think that hexagon or whatever it is taking up all that space.
Can I interject? That house has to be, that type of house has to be built there. I missed that point.
Oh.
So according to their bylaws, I have to build a topsider octagonal home. I wish I could build something a little different. But that's just,
well, that's kind of extraordinary.
Yeah, those are some covenants
Yeah.
there, right?
We have some river buffer issues,
Yeah.
so, that's more important than your house. But I recommend we defer it and see what we can come up with to get as far away from the critical line as we possibly can.
I have a question on the vegetation that you're talking about not disturbing. I mean, things grow so quickly around here. Are you doing shrubby things, or is it some?
when disturbance, I mean, yeah, it's just, the disturbance that we would do would be pretty small. Are you talking about like shrubby things, it's like what I plant?
If you moved it
Oh, if we
a
moved
little
it?
bit.
I don't know all the different palms, but there's the ones that are pretty, there's the smooth palms, and there's ones that are like kind of sharp as they go up. I don't know the
A
difference.
lot of them are pretty wild.
Yeah, so the wild ones, we've got the wild palms,
They'll come back.
but some of them are pretty large. And I'd like to prevent taking those out, because part of the spirit of river buffers are maintaining the vegetation. And I think I have an optimal plan here for maintaining vegetation, but.
Pleasure of the board.
I don't have a problem with it the way it is myself. Particularly in light of what he's gonna do with the runoff from the roof and everything.
Well, I think it's different than a lot of them we deal because it's so small. I mean, when we get something in here that's 8,000 square feet.
Yeah.
People wanted swimming pools bigger than this, and this,
Yeah.
I know, I think it is kind of unique with the shape of all those houses
Yeah.
that are in that area and the size lot, and really, you're not digging up and pouring concrete all along the bottom, like you would in normal raised house, it's
Right.
pretty unique. You're not gonna be messing up the root systems quite as
Yeah.
much, so I think it's conducive to minimizing. This is a unique situation.
is there a
Make
motion?
motion. I make a motion, we go ahead and approve the variance.
Okay, is there a second?
I second.
All in favor? Okay. Now we have, Ms. Arnholt for a short-term rental on River Oaks Drive, and there is a public comment on this one. Yeah, come to the podium, please.
Hello, I'm Carrie, and I'm just requesting permission for a short-term rental of my garage apartment at my address for River Oaks Drive.
So you live in the house that's attached to the garage, or?
It's not attached, but yeah, right next to.
And do you have any covenants?
No, ma'am.
Aren't you glad?
Yeah.
I have a question. You say maximum number of guests is 5.
Yes.
How many bedrooms are in that apartment?
So there's only one, but I put like a trundle, what do you call it, a day bed with a trundle underneath it, and then there's like a little rollaway bed in the, closet. But it doesn't have to be 5, I just put the option for 5, if they had like small children or something.
Any other questions for the applicant?
As long as she's living right next door.
Right. County? Do I hear a motion?
Public comment?
Oh, public comment, yes, sorry, thank you.
Sorry.
I had already
I
said there
thought we
was.
should have had one before we did.
Ms. Landon?
I do not have, I wasn't sure if I was gonna need to make a comment or not. I'm here to
Yes, she
support
was
her.
supporting me.
I'm in the neighborhood that does have covenants right next door.
Uh-huh.
And we're fine.
Okay.
But I would like to make a comment while I'm here. They don't pay people enough. And I appreciate you all.
Well, thank you.
Thank you.
You get paid?
I don't know, but I mean, if it's volunteer.
It's volunteer,
It's
yeah.
volunteer.
Okay, do I hear a motion?
I move we accept.
Is there a second?
Second.
All in favor? That's it. Does
Thank
any,
you very much.
oh, sure. Is there any old business? Any new business? Is there a motion to adjourn?
So moved.
Second.
All in favor?